Section 3 Mandamus. What is Mandamus? It's a special civil action wherein the petitioner prays that judgment be rendered, commanding a tribunal, corporation, board, officer, or person to perform an act which the law specifically enjoins as a duty resulting from an office, trust, or station, the performance of which the respondent has been unlawfully neglecting. It is also available against a person who unlawfully excludes another from the use and enjoyment of a right or office to which such other person is entitled. Like certiorari and prohibition, mandamus is only available when there is no other plain, speedy, and adequate remedy in the ordinary course of law. Q. Mandamus is also available against a person who unlawfully excludes another from the use and enjoyment of a right or office to which such other person is entitled. Distinguish this type of mandamus from quo warranto. Where the respondent merely excludes the petitioner from an office without usurping, intruding into, or unlawfully holding the office, the proper remedy is mandamus. If the respondent, however, claims any right to the office and usurps, intrudes into, or unlawfully holds it against the petitioner, the appropriate remedy would be quo warranto. Burgett versus Mayor, 94 Phil, 930. Give examples where mandamus would be proper. Mandamus is available to compel a judge to allow an appeal, where the same was timely and duly filed, and the proper fees failed. It has been held that a mandamus suit is proper to compel GSIS to continue paying a member's monthly pension. GSIS versus De Leon, November 17, 2010. Mandamus is proper to compel the Department of Budget and Management to pay retirement gratuity differentials of retired Court of Appeals justices. Association of Retired CA Justices versus Abad, July 10, 2018. May a transferee of shares of stock initiate an action for mandamus to compel the corporation to record the transfer of shares in its stock and transfer book, as well as to issue new stock certificates in his name? The answer is yes. It is settled jurisprudence that the registration of a transfer of share of stock and the consequent issuance of a new stock certificate to the transferee is a ministerial duty on the part of the corporation. Andaya versus Rural Bank of Cabadbaran, August 3, 2016. Note that mandamus does not lie solely against public officers, but even against private persons who have a ministerial duty. May mandamus issue to compel the performance of a discretionary duty? As a rule, no. Only ministerial duties may be compelled by mandamus and not discretionary ones. Tavera Luna versus Nable, 67 Phil 340. Where such discretion, however, can be legally exercised in only one way and it refuses to act in such manner, mandamus will lie to compel the court to exercise its discretion in accordance with law. Lifted from Florence D. Regalado Remedial Law Compendium. Does mandamus lie to compel the payment of the informer's reward? No. The grant of an informer's reward for the discovery, conviction, and punishment of tax offenses, it is discretionary quasi-judicial matter that cannot be the subject of a writ of mandamus. It is not a legally mandated ministerial duty. This reward cannot be given to a person who only makes sweeping averments about undisclosed wealth rather than specific tax offenses, and who fails to show that the information which he or she supplied was the undiscovered pivotal cause for the revelation of a tax offense, the conviction and or punishment of the persons liable, and an actual recovery made by the state. Lehigh versus Tan, 23 July 2018. An order of a regional trial court setting the case for pre-trial was duly sent and received by the plaintiff and defendant and their respective lawyers. On the date of the pre-trial, plaintiff and his counsel did not appear, and defendant moved to have plaintiff's complaint dismissed. The court denied the motion and reset the pretrial. Can defendant successfully sue for mandamus before a higher tribunal? No. No. The defendant cannot successfully sue for mandamus before a higher tribunal. In American Insurance Company versus Republic, L25478, October 23, 1967, the Supreme Court held that the trial court had the discretion but not the duty to declare a party non-suited. Under Rule 65 of the Rules of Court, mandamus only lies to compel the performance of ministerial acts, but not those involving discretion. Q. A files a complaint against B for recovery of title and possession of lands situated in Makati with the RTC of Pasig. B files a motion to dismiss for improper venue. The RTC Pasig judge denies B's motion to dismiss, which obviously was incorrect, alleging that the RTC judge unlawfully neglected the performance of an act which the law specifically enjoins as a duty resulting from an office. B files a petition for mandamus against the judge. Will mandamus lie? Reasons. No, mandamus will not lie. The Supreme Court has held that mandamus may not be directed against discretionary acts. Prohibition not mandamus is the proper remedy when a motion to dismiss is improperly denied. Enrique versus Macadaeg. May a mandamus lie to challenge a trial judge order of voluntary inhibition? Yes. While ordinarily mandamus will not prosper to compel a discretionary act, the writ shall issue in instances of gross abuse of discretion, manifest injustice, or palpable excess of authority, equivalent to denial of a settled right to which petitioner is entitled, and when there is no other plain, speedy, and adequate remedy. A judge's decision to refuse to act on account of some disqualification is not conclusive, and his competency may be determined on an application for mandamus to compel him to act. Where the motion for inhibition merely imputed bias or prejudice without any ground to support it, the judge's order of inhibition was not grounded on a just and valid cause. Pagoda Philippines versus Philippine Canning, GR 160966. Q. Alleging that his father passed away in 1992 and left a holographic will, which is now in the custody of his mother, Nixon filed with the RTC a petition for mandamus with damages to compel his mother to produce the will so that probate proceedings for the allowance of the will could be instituted. Was the filing of the petition for mandamus proper? No. This is because there is a plain, speedy, and adequate remedy in the ordinary course of law. That is, the filing of petition for probate under Section 1, Rule 76, and then moving for the production of the will under Section 2 to 5, Rule 75. Under Section 1, Rule 76, an interested person may petition the court having jurisdiction to have the will allowed, whether the same be in his possession or not, or is lost or destroyed. Uy versus Lee, January 15, 2010. It also appears that Nixon had a photocopy of the will. This would have been sufficient to prove the holographic will. Q. May mandamus lie to compel the performance of contractual duties? The answer is no. Contractual duties are not specifically enjoined by law, but by the agreement between the parties. The proper remedy, then, of the aggrieved party is to file an ordinary civil action for a specific performance. Kyoge versus Del Rosario, 46 Phil 337. May a mayor be compelled by mandamus to issue a business permit? No. A mayor cannot be compelled by mandamus to issue a business permit since the exercise of the same is a delegated police power and hence discretionary in nature. Lakap versus Sandiganbayan, June 21, 2017. Roble Arastre versus Villamor, 22 August 2006. And Rimanda versus Nagilian Emission Testing Center, GR 198860, July 23, 2012. Q. Once a decision of a court in an application for original registration of land ordering the LRA to issue the decree of registration has become final, will Mandamus lie to compel the LRA to issue the decree of registration? This time the answer is yes. However, Mandamus does not lie to compel LRA to issue the decree of registration where it appears that there is an existing title over the same land. Rodriguez versus CA, June 13, 2013. The reason is that it would violate the principle that a certificate of title is not subject to a collateral attack pursuant to the property registration decree. In a petition for Mandamus, may the petitioner recover damages from the respondent? Yes. Aside from praying for a judgment compelling the respondent to perform the ministerial duty, the petitioner may also pray that the court order the respondent to pay damages sustained by the petitioner by reason of the wrongful acts of the respondent. Section 3, Rule 65. Note that this provision allowing the recovery of damages is not found in certiorari and prohibition. Section 4. When petition filed. When may a petition for certiorari, prohibition, or mandamus be filed? The petition may be filed not later than 60 days from notice of the judgment, order, or resolution in case a motion for reconsideration or new trial is timely filed. Whether such motion is required or not, the 60-day period shall be counted from notice of the denial of said motion. Section 4, Rule 65. The 60-day period would not apply in case there is no judgment, order, or resolution to be assailed, as for instance in a mandamus petition where what is being assailed is the continuing refusal to perform a ministerial duty. Take note, however, that a petition for certiorari seeking to restrain or set aside actions taken by the Monetary Board of the BSP in respect of conservatorship, receivership, and liquidation proceedings should be filed within 10 days from receipt by the Board of Directors of the institution of the order directing conservatorship, receivership, or liquidation. That is Section 30, New Central Bank Act. Also, a petition for mandamus based on unlawful exclusion from public office may be filed within 1 year from such exclusion. Glano versus Rojas. May a motion for extension of time to file the petition under 65 be filed? Yes. While the provision in Section 465, which states that no extension of time to file the petition shall be granted except for the most compelling reason and in no case exceeding 15 days, was deleted by AM number 0712 SC, effective 27 December of 2007, this does not mean that the filing of a motion for extension was absolutely prohibited. If such were the intention, the deletion or the deleted portion could just have been simply reworded to state that no extension of time to file the petition shall be granted. Absent such a prohibition, motions for extension of time to file a petition under Rule 65 are allowed, subject to the court's sound discretion. Dom versus Sandikambayan, GR numbers 1823-82-83, February 24, 2010, and Bank. But only under exceptional and meritorious cases. Mid-Islands Power Generation Corporation versus Court of Appeals, GR 189191, February 29, 2012, and Republic versus St. Vincent de Paul Colleges, DR 1929-8. In Mid-Islands, the petition for certiorari filed with the Court of Appeals involved the operations of a Calapan diesel power plant in an imminent brownout in the entire province of Oriental Mindoro, where in St. Vincent de Paul Colleges, the Supreme Court took into account the fact that the CA had earlier granted the motion for extension of time and the public interest involved, that is, the expropriation of private property for public use. Note, views were expressed that courts other than the Supreme Court cannot grant an extension, as they are bound by the amendment of Section 4, Rule 65. By AM number 0712 SC, invoking Laguna Mets Corporation versus Kaalam, GR 185220. In Laguna Mets, the Supreme Court held that the Court of Appeals cannot grant an extension of time to file petition under 65, since the Court of Appeals would in effect be disregarding or modifying AM number 0712SC. Said views said that the ruling in Domdom was justified by the Supreme Court's equity jurisdiction, that is, the power to suspend the operation of rules of court or to exempt a particular case from its coverage, a power which can be exercised only by the Supreme Court. It should be noted, however, that in Mid-Island's case, the Supreme Court gave its imprimatur to the Court of Appeals' grant of an extension, stating that the matter was an exceptional and meritorious case. The practical effect of the rulings in Domdom, Mid-Islands, and St. Vincent's de Paul colleges is the reinstatement of the provision in Section 4, Rule 65, that no extension of time to file the petition shall be granted except for the most compelling reason, and in no case extending 15 days. Hence, not only the Supreme Court, but other courts as well may grant the extension, provided the matter involved is an exceptional and meritorious case. Where should the petition for under Rule 65 be filed? If the petition relates to the act or omission of a MTC or a corporation, a board, an officer, or a person, it shall be filed with the RTC exercising jurisdiction over the territorial area as defined by the Supreme Court. It may also be filed with the CA or with the Sandigan Bayan, whether or not in the same is in aid of the court's appellate jurisdiction. If the petition involves an act of an omission of a quasi-judicial agency, unless otherwise provided by law or these rules, the petition shall be filed with and be cognizable only by the CA. In election cases involving an act or an omission of an MTC or RTC, the petition shall be filed exclusively with the COMELEC in aid of its appellate jurisdiction. QAL ang network filed with the National Water Resources Board an application for a certificate of public convenience to operate and maintain a water service system in Aligis, Bacolod City. Bacolod City Water District opposed the application. The NWRB granted the application and Basiwa moved for the reconsideration of the order and to allow it to present evidence in support of its opposition. The NWRB granted the motion and allowed Basiwa to present evidence. A.Al ang Network's motion for reconsideration of the NWRB's order was denied. A.Al ang Network filed a petition for certiorari under Rule 65 with the RTC, which dismissed the petition stating that it should have been filed with the Court of Appeals. Was the RTC's dismissal order proper? The answer is yes. Section 4, Rule 65 provides that if the petition involves an act or omission of a quasi-judicial agency like the NWRB, the petition under Rule 65 shall be filed with and cognizable only by the Court of Appeals. The fact that the NWRB is not mentioned in Section 1, Rule 43 does not mean that it is not a quasi-judicial agency, since the list is Section 1, Rule 43 is not meant to be exclusive, as shown by the use of the word among. National Water Resources Board versus A.Al ang Network. April 8, 2010. Q. The Department of Health issued a cease and desist order, CDO, against the GCC-approved Medical Center Association, or GAMCA, and joining it from implementing the DEC referral system in which OFW applicants to the Gulf countries should have their medical examination only in the Gulf Cooperative Countries, or GCC. Approved clinics. GAMCA filed with RTC of Pasay City a petition for certiorari under Rule 65 seeking to enjoin the DOH from implementing the CDO. Was the DOH acting in a quasi-judicial capacity when it issued the CDO? B. Was the petition properly filed with the RTC? Answer to letter A is yes. The DOH CDO letter directed GAMCA to cease and desist from engaging in the referral decking system practice within 3 days from receipt of the year. By issuing the CDO letter implementing Section 16 of RA 10022, the DOH made the finding of the fact that GAMCA implements the referral decking system, and 2. Applied Section 16 of RA 122 to conclude that GAMCA's practice is prohibited by law and should be stopped. From this perspective, the DOH acted in a quasi-judicial capacity. Its CDO letter determined a question of fact and applied the legislative policy prohibiting the referral decking system practice. Notably, CDOs have been described and treated as a quasi-judicial acts in past cases and had even been described as similar to the remedy of the injunction granted by the court. Answer to letter B, no. Acts are omissioned by quasi-judicial agencies, regardless of whether the remedy involves a Rule 43 appeal or a Rule 65 petition for certiorari, is cognizable by the Court of Appeals. The provision in Section 4 Rule 65 requiring the certiorari petitions challenging quasi-judicial acts to be filed with the CA is in full accord with Section 9, Number 1 and 3 of Batas Pambansa, Bilang 129. Thus, by law and by Supreme Court rules, the CA is the court with the exclusive original jurisdiction to entertain petitions for certiorari and prohibition against quasi-judicial agencies. Association of Medical Clinics versus GCC Medical Center, December 6, 2016. Private respondent filed an election protest case against the petitioner before the RTC. The RTC issued an order finding the service of summons against the petitioner valid and declaring the petitioner's answers filed out of time and thus authorizing the reception of evidence ex parte. Petitioner filed a petition for certiorari with the Supreme Court. Private respondent contends that the petition for certiorari should have been filed with the Comelec pursuant to Section 4, Rule 65. The petitioner, on the other hand, contends that a certiorari proceeding to set aside an interlocutory order is not in aid of appellate jurisdiction. Was the Rule 65 petition properly filed with the Supreme Court? No. If a case may be appealed to a particular court or judicial tribunal or body, then said court or judicial tribunal or body has jurisdiction to issue the extraordinary writ of certiorari in aid of its appellate jurisdiction, since it is the Comelec which has jurisdiction to take cognizance of an appeal from the decision of the regional trial court election contest involving elective municipal officials, then it is also the Comelec which has jurisdiction to issue a writ of certiorari in aid of its appellate jurisdiction. Galang versus Hieronimo, 22 February 2011. Respondents and costs in certain cases. Who should be joined as respondents in a Rule 65 petition? When the petition filed relates to the acts or omission of a judge, court, quasi-judicial agency, tribunal, corporation, board, officer, or person, and the petitioner shall join as private respondent or respondents with such public respondent or respondents the person or persons interested in sustaining the proceedings. When the petition filed relates to the acts or omission of a judge, court, quasi-judicial agency, tribunal, corporation, board, officer, or person, the petitioner shall join as private respondent or respondents with such public respondent or respondents the person or persons interested in sustaining the proceedings. That's just repeating. In a Rule 65 petition for certiorari filed with the RTC wherein the accused petitioner questions the denial of the MTC of his application for probation, the petitioner failed to implead the offended party as a private respondent. Hence, the RTC dismissed the petition for failure to comply with Section 5, Rule 65. Was the dismissal proper? In a petition for certiorari under Rule 65, the failure to implead the private complainant pursuant to Section 5 of Rule 65 will not warrant the dismissal of the petition. Section 11, Rule 3 states that neither misjoinder nor non-joinder of parties is a ground for the dismissal of an action. Thus, the trial court should have ordered petitioner to add private complainant as a respondent to the case. Kuya versus People. 12 October 2011. Whose duty is it to appear in behalf of the respondents? It shall be the duty of the private respondent to appear and defend both in his own behalf and in behalf of the public respondent. Unless otherwise specifically directed by the court where the petition is pending, the public respondents shall not appear in or file an answer or comment to the petition or any pleading therein. If the case is elevated to a higher court by either party, the public respondents shall be included therein as nominal parties. However, unless otherwise specifically directed by the court, they shall not appear or participate in the proceeding. That is still Section 5, Rule 65. Will the filing of the petition under Rule 65 interrupt the course of the principal case? No, unless a temporary restraining order or a writ of preliminary injunction has been issued against the public respondent from further proceeding in the case. The public respondent shall proceed with the principal case within 10 days from the filing of petition for certiorari with a higher court or tribunal, absent a TRO or writ of preliminary injunction, or upon its expiration. Failure of the public respondent to proceed with the principal case may be a ground for an administrative charge. However, where a person has been adjudged in direct contempt, and he avails himself of the remedies of certiorari or prohibition, the execution of the judgment shall be suspended pending resolution of the petition, provided such person files a bond. Section 2 of Rule 71. QP filed a petition for mandamus with the RTC against the Register of Deeds and the Land Registration Authority in order to compel the latter to issue to him a transfer certificate of title. The respondents filed a motion to dismiss on the ground that P should have elevated the matter by way of consulta. The RTC denied the motion to dismiss as well as the succeeding motion for reconsideration by the respondents. The respondents then filed a special civil action for certiorari with the Court of Appeals with a prayer for the issuance of a temporary restraining order and writ of preliminary injunction. After 20 days from the filing of the petition for certiorari, the CA required P to file a comment but did not issue a TRO or writ of preliminary injunction. The RTC then issued an order suspending the proceedings before it during the pendency of the certiorari case before the CA. P moved for the continuation of the proceedings, but the RTC denied P's motion. Is the action of the RTC proper? B. May the RTC judge be administratively charged? Answer to letter A, no. The action of the RTC is not proper. Under Section 7, Rule 65, the public respondent shall proceed with the principal case within 10 days from the filing of the petition for certiorari with the higher court or tribunal, absent a temporary restraining order or a preliminary injunction, or upon its expiration. Section 7, Rule 65, as amended by AM number 07712 SC, December 12, 2007. Answer to letter B is yes. Failure of the public respondent to proceed with the principal case may be a ground for an administrative charge.